Commissioner Johnson is a 43-year veteran of the Philadelphia Police Department. He became the 13th Police Commissioner of the City of Philadelphia on January 4th, 2002, and throughout his notable career, he's been awarded over 30 departmental commendations. He is also the recipient of numerous community service and humanitarian awards. Commissioner Johnson now teaches at Springfield College in Wilmington, Delaware. One more time, Commissioner Leon Goodman has previously served as a district attorney for both Allegheny County and the City of Philadelphia. In Philadelphia, Mr. Goodman was assigned to the elite homicide unit, where he handled for over 4 years the most difficult of all types of cases, homicides. He handled in excess of 60 cases with a conviction rate of almost 85%. Mr. Goodman is currently Chief Counsel for the Office of Audit and Compliance at the Philadelphia Housing Authority. Mr. Leon Goodman. We should have that. Charles Gibbs is no stranger to Widener University School of Law. As a litigator who focuses his practice on representing individuals, nonprofit organizations, and businesses on a wide range of matters. Mr. Gibbs represents plaintiffs and defendants in state and federal courts in matters involving election law, labor and employment matters, real estate disputes, complex commercial litigation, and white-collar criminal defense. Additionally, Mr. Gibbs' practice includes zoning and land use, as well as local government affairs. Mr. Gibbs is very active in the community, having served in numerous community leadership roles, and he was recognized in the year 2000 as the city's youngest block captain, and by the Philadelphia Tribune magazine as one of the top 10 people to watch under 40 in 2005. Mr. Gibbs is a cum laude graduate of the Widener University School of Law, and he is also former president of the Black Law Students Association. Please join me in welcoming whom I call President Emeritus Gibbs. Lastly, the Reverend Elaine Newberry is the Associate Pastor of Fellowship at Enon Tabernacle Baptist Church in Philadelphia, and through his ministry, Enon is committed to developing effective strategies to deter youth violence and to positively impact the local, national, and international community. Please help me welcome Reverend Elaine Newberry. And our moderator this evening is Professor Justin Holbrook, who teaches, writes, and lectures in the areas of veterans and military law, criminal law, and public international law. Prior to joining the faculty of Widener's Delaware campus, Professor Holbrook worked as an associate at King and Spalding in Atlanta, Georgia, where he concentrated on labor and employment litigation. He then served 6 years as an active duty judge advocate in the United States Air Force. Professor Justin Holbrook.
Otherwise, I'll refuse to moderate. It all begins with. Okay, so let me just say to each of my colleagues up here and to the panelists how terrifically grateful we are that you took time out of your very busy schedules to come and chat with us about this important matter. On behalf of Widener Law School, we thank you very much. So what I wanted to do for the next few minutes is to really ask a series of directed questions to each of you, to evoke your thoughts about the incident that has occurred, to get any suggestions, ideas that you have, perhaps for us, about how we can interpret and better understand this situation. And then I think we'll transition to taking questions from the audience. We already have one pending question, which I'll keep on the back burner for now. But we'll go in that order. And I'll try to direct my questions to each of you specifically. But I think if you feel sort of the impulse to jump in, to make some additional comments, even if the question was directed to someone else. We have a small enough panel that feel free to do that because we really want your thoughts, your ideas, your inspiration, your experience. So thanks very much. So first, Reverend Newberry, I'll sort of direct this question to you if I can, sir. Part of the public response over Trayvon Martin's death involves sort of outrage, accusations of racial profiling. So I'd like to start there. Million hoodie marches have been staged across the U.S. The entire roster of the Miami Heat, for example, tweeted photos of themselves wearing hoodies. Over 2.2 million people have signed Miss Martin's Change.org petition calling for Mr. Zimmerman's immediate arrest. So the first question is really a general question, and it is this. Is the public outrage, in your view, appropriate and justified in this case?
Well, from our perspective, and consider I do represent the ecumenical community tonight, and I believe the outrage is indeed justified, and I don't know if it's totally outrage, but I think it's a suitable response considering a young man who was killed at the point of a gun. And while we see this constantly going on in America, we're clear by some of the misunderstandings involving this case and the particular arrest of this individual who happened to be of a different hue, which of course causes much excitement on the part of people. And the good thing about this is that all races are involved in this outrage and this outcry across America. I was just, before I came earlier, I was listening in to Reverend Al Sharpton, and his National Action Network is having their convention this Wednesday. But what I do appreciate much about this is that everyone can look at this case and they can say, let's flip the script. If Mr. Zimmerman were of a different hue and the victim, the one who was killed, was of a different hue, we believe that justice would have been dispensed differently. So surely I'd say the outcry is justified.
Okay.
I'll jump in there just for a moment. Good evening. I think that it's very important to note that Americans don't like when people get away with murder, or we perceive they get away with murder. O.J. Simpson's trial happened. People didn't like the outcome because some people thought he got away with murder. Casey Anthony, a white female, was found not guilty. There was an outcry because people thought she got away with murder. Here you have a person. We have the two most important facts, and there's a former district attorney, he can correct me if I'm wrong, but the two most important facts for probable cause are, was there a crime committed, and is it more likely than not that this person committed the crime? The answer to that question is yes, there was a crime committed, a person is dead on the street, and is it more likely than not that George Zimmerman shot him? We know these two things. That is now time for the justice system to take its role. There's an outcry, there's an anger. I think also that is undergirding this whole thing, there is I believe, a subconscious criminalization of young African American men. They're not just white people or Hispanic people, but even black people are guilty of. The reality is that myself with a hoodie on, certain nights I look intimidating. I can tell you that I was terribly embarrassed. There was a Million Hoodie March going on downtown. I'm walking with my fiance to dinner, and I see 6 guys walking towards me with hoodies. Now, I had just got finished wearing my hoodie because of this shooting, and I said, wait a minute, something's not right. I am going to cross the street. The reality was, they were on their way to protest and to call attention to the fact that there is a subconscious thing that we've done with young African American men. And I think that is where some of the anger is coming from in the African American community. Barack Obama said, if I had a son, he would look like Trayvon Martin. I think everybody's, like the Reverend said, is saying this could be my son, this could be me, this could be my friend.
Okay, gotta help me out here, Roger. I crept back up here again, and it wasn't on purpose. There we go. Okay.
You got a person thought.
Apparently so. They're few and far between. So, Mr. Reverend Newberry suggested that if the race of the two individuals involved were different, that the public outcry were different. Is that, in your view, sort of an appropriate characterization, or do you feel there are legal underpinnings that are at play here that doesn't quite capture?
I have to agree with Charles in this matter in the sense that Casey Anthony, she was white, and she got probably more death threats than OJ did. It's that outrage that goes along with someone that escapes justice. In this particular circumstance, it's my personal belief that the fact is, whether he was white or black, you have a situation where someone is killed, a juvenile, basically someone who is doing something that any one of us would have the right to do, walking back to your parents' house, and killed by an individual who had been told multiple times to cease and desist. Don't do it. Told this while he's in his vehicle, exits his vehicle, and escalates the particular circumstance. So it's my personal belief, looking at this, the outrage comes from the fact that an individual decided to take the matter of life and death into his own hands and killed someone over absolutely nothing. White or black, you would still have that outrage.
So, Commissioner Johnson, if that's the case, that white or black, the outrage would still exist because of the public perception that a killer, perhaps, has gone free, why then is race relevant to the discussion, or why has it become so important to this discussion?
I think because of a couple of things. I think as far as the police department is concerned, I really think from the very beginning, not saying there was a cover-up, but there was mistakes made. In any homicide investigation, the very first thing that you have to do is identify the victim. How they can go 48 hours without even identifying the victim, which would seem like it would be so easy to do. He had a cell phone there. You can easily just pick up the cell phone and call back. The other thing, the body tells you a lot. They can very well have went there and found out the trajectory of the bullet, whether there's any powder burns, the fuller the wound, the cleaner the wound. The other thing that I think is very important, and in any homicide investigation, you do neighborhood surveys. You interview everyone. You take negative interviews as well as you take positive interviews. That's why you can't have somebody come every 3 or 4 days and says this is something that happened that day. And I think for them also to have Zimmerman come in, and he's claiming that he has injuries, and I'm not sure what Florida would do, but in the Philadelphia Police Department, if he claimed he had injuries, we would take him to the hospital and let him deny treatment right there at the hospital. If nothing else, take photographs of him. But I think as far as the police department is concerned, from the very beginning, they decided to took this person's word and just ended the investigation. Like one of the other gentlemen says, I think this was reversed, the race was reversed, it would have been handled completely different. But it's still amazing to me how anybody can go 48 hours without identifying the victim. When he had a phone there, you could have called there, and they did go out there and do the neighborhood surveys. It seemed like the whole investigation stopped that night, which as far as law enforcement is concerned, it just doesn't make sense.
So is it the case then, and I'll ask this of the entire panel, that race is an important issue in the case, not necessarily because Zimmerman was engaged in racial profiling, but because the police department refused to investigate the case like they would have had the victim been of a different race? Or is that an incorrect statement?
I think that's a correct statement.
I would tend to agree with that.
I don't think there would be any doubt that if it was reversal, and it was a white male on the ground and a black male with a gun, then that man would have been arrested that night. And the fact that he come in there and make a formal statement and to give him his gun back and not do anything and just leave it there, it says again, and I know I'm repeating myself, how can you go 40, in the worst circumstances, even if he didn't use the cell phone was there, there's times that you take photographs and go neighbor to neighbor to find out who this kid is. He belongs there, Zimmerman didn't. From the very beginning, from that investigation, it showed that there's something wrong. You have a male who's armed and a male who's unarmed. He definitely would have been arrested if the race was reversed.
Any thoughts for the panelists on that point?
I agree with my former colleague, Commissioner Johnson. I think you've never heard that before.
No, I haven't.
Let me shift gears for just a second, come back to you, Reverend Newberry, if I can. And the question is this: whenever there is such a public outcry, such as a case like this, how responsive should law enforcement authorities be to that public outcry? In other words, there's a petition calling for Zimmerman's arrest. How responsive should prosecutors be, or the police, for instance, in determining that the legal standard has been met and that they should proceed with the investigation or prosecution? Any thoughts as a community leader on that point? How responsive should the police be?
Well, I believe the police have probably the most important position in all of this, which we see it did not happen, because when you had the lead investigators who takes a position and then all of a sudden his position disappears, which was crucial, we feel, to this particular investigation, and then the others who are in leadership of these particular agencies, law enforcement agencies, of course, do not respond in kind, then the public has to cry out about it. I do believe too in this instance, for this young man, and we're clear about this, that justice has to prevail one way or the other. And now what we're saying is we're seeing people crying out all over America, but what we don't want to see is a situation whereby this outcry pours into the type of violence that could ruin cities as we've seen in the 60s and of course primarily the 60s and in the 70s. So we're hoping that that will not happen.
Okay, other panelists, how responsive should a prosecutor's office be to a public outcry? Or should they insulate themselves and conduct their own investigation and then make an impartial decision if such a thing is even possible?
You wanna go first?
On this, I think, yeah, of everyone here, this is probably my area. I've been in 2 different prosecutors' offices under 4 different district attorneys. And one of the things that I've learned unequivocally is that the decision to prosecute cannot be based on public pressure. It must be based on an independent review of the facts in question, dispassionately looking at those facts in terms of what can you prove with it, anticipating whatever the defenses could be, and whether those defenses in effect would cancel out any type of criminality, but most importantly, looking at it in terms of the cold, hard facts.
Well, we know that that doesn't happen, though. So despite what Leon just told you, I can assure you when Leon was in the office, that didn't happen.
And Mr. Harris will also assure you that when I tried cases, some of which were against him, that was how I tried my cases. But
Touche.
in regards to looking at even the report, which is available, the initial police report, you actually see references on there from the initial officers and the charge that they recommended, which was negligent homicide, voluntary manslaughter. So the first officers on the scene, looking at it from their standpoint, seem to suggest, okay, at a minimum, we're talking manslaughter here. So that's the approach that must be taken by the prosecutor. You can't basically govern or decide based on public opinion, because when you do that, you accept cases that, frankly, you probably shouldn't. And that's a miscarriage of justice.
If I could jump in, and Mr. Harris may know more about this case. I worked in the street administration, and Sylvester Johnson can attest to this also. The Philadelphia District Attorney's Office decided to prosecute 3 young African-American men in the early 2000s in what they called the Lex Street Massacre. Mr. Harris was a criminal defense attorney. There was a public outcry. People wanted blood and justice. In neighborhood, people were protesting. There were no million hoodie marches, but people were fired up.
And what happened?
And they arrested 4 people.
They arrested people who were not involved.
The 4 wrong people, exactly, they were not involved. And when someone took the opportunity to do a dispassionate view of the evidence, they found the right 4 people.
Well, that's interesting. After a judge said to the prosecutor said that I'm going to prosecute them till hell freezes over, is what the prosecutor said.
That's correct. That's exactly what happened.
A judge decided to toss the case out, and that's a different story. Mr. Harris is one of the criminal defense attorneys on that matter. I don't know if I make that point to say it sounds like the ivory tower of truth, that we can have this dispassionate view. Prosecutors, by and large, are elected. They're thinking about election. You have a race issue. They're thinking about that. If you don't think that the public outcry, the public non-outcry plays a part, you're a fool. I think that you have district attorneys in the charging unit who do their best. I think you have line district attorneys and homicide district attorneys. When it comes to that person who's elected, who has to stand before voters every 4 years, the public sentiment means something. You won't hear a prosecutor who will say, I'll risk my career on this. What you hear is, I'm running for re-election, please vote for me.
But I think what you had is almost 3 weeks before there was any outcry. And normally during an investigation, we would do the investigation, contact the prosecutor's office. He might say, look, there's not enough this night, do more.
Exactly.
And it depends on what he says, we will go out there and do more, but we just wouldn't end it. I mean, he might say at this point, look, we'll wait for the autopsy. They did an autopsy on Trayvon. They checked for alcohol and narcotics. They didn't do an autopsy to check whether there's any powder burns or how close the wound was or anything else involved in that, which didn't make a whole lot of sense. And also, that you don't even do the autopsy until almost 3 days later, then there's really something wrong with the whole investigation. But we understand that the prosecutor has to take this to court. But he normally doesn't say, well, end it, there's not enough this night. He might let Zimmerman go that night and we're gonna arrest him 3 or 4 days from now based on what the prosecutor wants us to go out there and do. But the investigation goes on. And it says it seemed like in this particular case, you had a black male killed and no one cared until 3 weeks later when it started becoming public. And then these things come out. Now you can't go back. Now you gotta start the investigation from the very beginning. His clothes could have told you some things, whether there was things, what part of the body was he really shot in? What was the objective of the wound? There were so much things that the body could have told them that particular night, if not that night, the very next day. The prosecutor could very well have said that night, look, there's not enough today, but do a little more. But obviously, the investigators felt as though there was enough that night. So you sit there and you discuss it and you keep the investigation going on. You don't close it that night and end it.
Mr. Harris, welcome to our
Thank you
panel.
very much. I appreciate it. Thank you for
Allow
having
an
me.
opportunity to jump in and respond at this point to the pending question.
Well, I think the Commissioner raised a good point. I mean, particularly if you're talking about a close-range shooting, ordinarily, that's something that you want to find. You'll find that early through stippling, or when it's a close-range shooting, and Leon can tell you even better than I can. Certainly, if it's a close-range shooting, you can find through the stippling. And so you'll find that out early on in the process.
Describe stippling for us.
Well, stippling, I guess, basically is something that when a firearm connects with fabric, it creates a sort of burning sensation. And the burning sensation that it leaves behind is called stippling.
No, that's soot.
Oh, that's soot. Okay, soot is the powder. I thought soot was the powder.
Stippling is within,
Within close range.
within 3 feet
Okay,
or
within
less.
3 feet.
Soot is when you have it right up on top.
Right up on top of you. So either way, we would have something. All
And they
right?
both begin with the letter S.
Right.
Whether it's stippling or soot, and it's been a long time since I tried a homicide case. But either way, you're going to have something to demonstrate that there was a close range shooting. In this case, as I understand it, Commissioner Johnson just mentioned that they didn't even actually look for whether or not this was a close range shooting. They were actually looking to determine whether or not he had any narcotics or a substance in his body. So that's something that would be contrary to what ordinarily would be done in a prosecution of or an investigation of a homicide.
With all due respect to Commissioner Johnson and Mr. Harris, the autopsy report has not been released yet.
Exactly.
We don't know what happened. And I will correct a statement. We know that the body was released on the 3rd day. The medical examiner's office said they called the funeral director on a Saturday night and he didn't pick it up till Monday morning. So that presupposes that this autopsy was done and the body was packaged for delivery to the funeral home. But until we see an autopsy report, I don't know if we know how the autopsy was done.
Well, I can certainly tell you the police, law enforcement, but if they'd known that it was a close range shooting, they would have already released that portion.
Sure,
But-
I'm sorry.
They don't need that for an autopsy.
The autopsy report would also indicate that, though, because that's one of the things that the medical examiner looks for. He looks for those indications of how close the weapon was based on whether or not there's soot, stippling, powder burns,
Correct.
or even, for that matter, impact, indicating that the weapon was actually against the skin. So those are little small things that, frankly, could have made a difference here in the charging and may make a difference ultimately.
But certainly that's
also-
something that would have been done in the first few days.
It should have been done immediately.
Right. The other thing, they can tell whether he was shot while he was on the ground or someone shot while he was
Exactly.
on the ground and shot up.
Shot up.
I mean,
Right.
those things. And I don't think any of us at this point know exactly what happened. We're all going by what the news media has told us. And depending on what news media you listen to, you don't know what's right or what's wrong. At this point, again, I don't know exactly what happened. I know based on what I, heard, that the autopsy was not performed. He was buried before they came out and said they did an autopsy based on alcohol or narcotics. But I'm saying there's so many things the body could have told you that night or the next day that wasn't done, even with the clothing. And again, you do neighborhood surveys, you interview everyone. A negative interview is just as important as a positive interview. You can't have somebody come out a month later and say, look, I've seen this happen, or I've seen that happen. Where they had the opportunity to go door to door to door that night to find out exactly what people were saying, how many shots they heard, and they interviewed the person, the call taker, what they're seeing. It seemed like Zimmerman had a history of violence. All these things, there was enough circumstances as far as I'm concerned, it's my opinion, that night that he should have been arrested.
So that leads us to sort of a different question, which relates to that, and that is the probable cause standard. Understanding that not all of us, or that we don't possess the facts of the case, do you feel in this case that police had sufficient probable cause to make an arrest? And do you find any concern with the idea that the police failed to perform any drug or alcohol testing on Zimmerman, although they did so on the body of Trayvon Martin? And I'll direct that.
Let's go to the dispassionate prosecutor.
In this particular circumstance, yes.
I thought I'd give you the first chance. Mr. Harris, we'll go to Mr. Goodman first.
I mean, my review of what I've seen, there's a police report that purports to be the report that was prepared subsequent or immediately subsequent to this. It would suggest to me that there was at least probable cause as it relates to manslaughter at a minimum, and the other factors which could be determined through the autopsy could raise that to as high as first-degree murder.
Manslaughter?
Minimum. Emphasize, minimum, which is the holding charge.
How about murder generally? Wouldn't you charge murder generally?
And this, if this was a Pennsylvania case, yeah, I would charge murder
You
generally.
charge murder generally.
In this case, yes. Because under the circumstances, looking at the 911 call where he was told, Zimmerman I'm referring to, was told multiple times to cease and desist. The fact that he was in his vehicle, the fact that he was told and continued to follow the location where they were ultimately recovered as compared to where the vehicle was when the last call was, because they referenced it was near a clubhouse, which was there was some distance from the clubhouse to where they ultimately found the body. So you're in a situation when you had some distance, you had instructions, you had an individual who's acting above and beyond the course. As a prosecutor, I think I'd have a shot at a first on this, even with Mr. Harris as a defense attorney.
Let me just jump in with at least an alternate version on behalf of George Zimmerman, at least, that he's proposing, and then Mr. Harrison will jump in with a response. So his current version of accounts, which of course remains open to dispute, is that he was proceeding after Mr. Martin, that at some point the police told him on the 911 call to stop chasing Mr. Martin, that he obeyed that order, and then he turned around and then he went back to his vehicle. And that as he was approaching his vehicle again, that's when Mr. Martin, who had apparently gone home during this time and then come back out of his house again, according to some reports, approached Mr. Zimmerman at his vehicle, confronted him there, and then they ended up, however, some distance away where the altercation eventually took place. So I only toss that as an alternative narrative, which is at least being discussed. Mr. Harris.
Well, if that's the case, then he was no longer pursuing Mr. Martin. And in that case, then it would be an instance as to whether or not it was reasonable for him to respond appropriately with deadly force.
And that goes to a question which one of our students asked, and that was whether or not the reasonableness of his fear was subjective, or needed to be subjective, or must be objective in order to be offered as a reliable defense.
I think the standard requires it to be an objective defense.
Exactly.
So it has to be an objective standard. So if he believed in his own state of mind that it was reasonable at the time, it's going to be an objective standard to determine whether or not that was appropriate and proportional.
Any thoughts on the issue of probable cause in this case and the drug and alcohol testing, or lack of testing?
Well, I think the lack of testing is particularly important. The fact that they didn't determine whether or not Mr. Zimmerman had anything in his system certainly would have gone to the question as to his reasonableness of his actions at the time and whether or not he was beyond the bounds of what was appropriate under the circumstances. And so if you're looking to determine whether or not he was aggressive, and certainly there could have been certain narcotics that would certainly cause that, certain stimulants may have caused that, and we don't know that because unfortunately he wasn't tested. But that certainly would have been a factor that I think law enforcement would have taken into consideration. But ordinarily, and I would ask the commissioner, that's not something that's typically done to someone under these circumstances. They ordinarily wouldn't test to determine whether or not that person was actually under the influence of drugs or alcohol.
The victim, you're saying?
Well, Mr. Zimmerman,
The shooter.
in this case, the shooter.
Especially if he's not under arrest.
Even to determine probable cause, they would not have tested him for drugs or alcohol in most circumstances.
But as the commissioner referenced, he would have taken him to the hospital, which would have had the opportunity conceivably to do that type of testing.
If he was injured significantly.
Which is what he's claiming here.
Let me introduce a new line of questioning if I can. On March 22nd, Florida Governor Rick Scott announced that another state attorney, Angela Corey, would now serve as the lead prosecutor, so essentially removing jurisdiction from the local prosecutor. Today, however, she canceled the scheduled grand jury that was due to take place on April the 10th, and announced that her office would make the sole decision whether or not to file charges against Zimmerman. If she decides to charge Zimmerman and he is arrested, the question is, why might the police and prosecution now believe they have probable cause that they failed to find so earlier? That's sort of a side question. My real interest in your real question, I guess, is what do you think about her decision to cancel the grand jury and to make her office the sole decision authority to file the information or complaint?
Well, I thought it was unique in the first place that she was going to impanel a grand jury. So I understand it, over 105 cases in which she's operated as a special prosecutor, she's never impaneled a grand jury. So that would have been unique in this situation from the beginning. So I do find that, I doubt very seriously there are going to be any differences in terms of what she's going to do from what the prosecution decided to do in the first place. I'd be very surprised.
To what extent, as either a defense attorney or a prosecuting attorney, should self-defense come into play in deciding whether or not to even make an arrest? Is it appropriate to set that aside, to go ahead and make the arrest based on the evidence, and allow that to come out based on the facts of the case?
Well,
Maybe I'll start with you, Commissioner Johnson, from the police perspective first, and then we'll move on to the legal perspective.
Well, I'll say this from the police point of view, all these things from the autopsy and from, the information that the police have, whether it should move forward, it says, you got a person who is armed with a gun. The average person is not going to, and I'm sure he had the gun in his hand. I'm sure he didn't have that gun in his waistband or gun in the back of him. He had the gun in his hand. It's hard to believe that you have a young child or even an adult would attack a person with a weapon in his hand. Again, it's very important, at least what I would look at, is what position was Martin in, what position was Zimmerman in? Was Zimmerman on top of him when he got shot? Was he on the bottom when he got shot? The autopsy can tell that. And like it says, the further the shooting, the cleaner the wound. They could tell that. There's so many other things that they could tell. And get all these people who are now coming out with their statements, they re-interview everybody in that media area that night. I says, based on the things that I know from the news media, there was enough evidence that night to arrest him, and I still think there's enough evidence to arrest him based on all the circumstantial evidence that's there. You have a person that's in the car with a weapon, you have a kid that's walking in the neighborhood that he belongs in. I understand Zimmerman didn't even live in that neighborhood. The one who's shot is the one that belongs in the neighborhood. The one that did the shooting didn't belong in the neighborhood. They normally wouldn't do a alcohol test on Zimmerman because they're not going to make a defense for him. If that's his defense, we're not going to make a defense for him. That's something he's going to have to bring up later on himself. But there would have been a lot of questions of what position he was in, what position was Martin in, how many times did you shoot, why did you shoot? I mean, there's a whole lot of things, the formal statement that would be made that night. The investigation couldn't just have lasted. I understand the shooting happened at 2:25, I mean, based on a report, and an hour later, they're interviewing Zimmerman. And 2 or 3 hours later, he's walking out the police station. It's seen from the very beginning, the police, once you start your investigation, you're preparing for court. You have to put that in mind, you're preparing for court, because anything you make a mistake that night is going to come up in court later on. And I think that the police department didn't really care. I know I repeat myself again, is you had a black kid shot, it went 2 or 3 weeks without nobody's making any statements, nobody making any outcry at all, and it was done. Once the outcry came out and the investigation, they're going to have to start from scratch, and starting from scratch, it's going to be very important. I think, not so much the autopsy, the grand jury, you have a lot of people go in front. I don't know if you've been in front of a grand jury. There's people from the citizens sit there, sometimes they're eating, doing whatever they want to do, and they're just based on what the prosecutor's saying. She's going to have to go strictly by the facts. And I think that's even more important that she goes by the facts instead of the grand jury making that indictment.
So
that's my opinion.
Suggesting, Commissioner, that a grand jury is not an appropriate forum to make charging determinations?
In this particular case, I don't think it is. An investigative grand jury, I think, is very, very helpful. when you want everything to be brought up. But a lot of times the investigative grand jury, and the grand jury, most of the time, at least the ones I'm experienced with, is normally from the prosecutor point of view. And the prosecutors put what he wants to put on place. There's no defense. There's nothing there. They put what he wants to put on and don't put it what they don't want to put it on. Then all of a sudden you have an indictment.
But in this case, if the local district attorney's office, prosecutor's office, made a determination that there wasn't probable cause for an arrest, don't you think, given the public outcry that we currently have, don't you think that an investigative or a prosecuting grand jury, which is what I understand in this county, don't you think that that would be an appropriate objective form to make that determination, since clearly the office may have some bias now?
Well, it appears like the prosecutors that made the decision that might not to prosecute would put things on to make sure or give reason why they didn't prosecute.
Okay.
And I think that the prosecutor's office, I think the police department on purpose released that tape showing George Zimmerman in handcuffs. I think that was the police department punting and saying to us without saying, look, we thought he did something wrong. Here's our report. We said manslaughter. He's in handcuffs. Somebody, i.e. the prosecutor, said it's not enough to prosecute. So that prosecutor has an issue. Now there's this new the special prosecutor. I don't know if, I think that to answer your question, and my criminal procedure professor's here, so I'm not going to try to pretend like I will lay out a legal standard on what probable cause is. However, I think that there is some, hi, Professor Martin. I think here we had probable cause. I said in the beginning, this guy gets held for court. I think everyone agrees that he gets held for court for murder. I think everyone agrees, we know the most important facts. We know who the shooter was, and we know who the victim was. We know the victim didn't have a gun. We know that self-defense is exactly that, a defense at trial.
Exactly.
It's a defense.
It's a defense. It's not
on the
something to
street corner.
preclude.
Right.
It's
You
a
know,
defense.
the defense
Yeah.
in the police car is, officer, I didn't see the red light. And a cop can decide, okay, maybe you didn't see it, I'll let you go. You can't say, hey, I shot the guy, but you know, I was really scared. Wink, wink, nod, nod. Have a good night, officer. That's not how the system works. It is a defense.
Well, as I understand it, if you look at the statistics in that jurisdiction, apparently there were over 100 and something cases in Florida where they have actually availed themselves of this particular defense of stand your ground. And so, of those, 70% of them are somewhere in the north of 70% of those defenses led in a fatality. So people actually were killed as a result of this legislation, the stand your ground legislation. And of those, approximately 25 to 40 of those individuals actually were not even prosecuted. So it doesn't appear necessarily on its face that the way that the prosecutors acted in this particular circumstances was an aberration. But at the same time, it does call into question the application of this law. Are the police officers in the best position to make that sort of decision? Probably not.
No.
Are we talking about a prosecutor's office who has deferred to law enforcement officers in a situation where they ordinarily wouldn't defer? And then why are they? So, I mean, those are certain questions that are separate and distinct from the race question, which I think is particularly important. But separate and apart from that, we need to look at all of those other previous cases, look at the dynamics of those other cases when the district attorney's office has failed to prosecute individuals that were actually availing themselves of the stand your ground defense.
I think one of the issues as it relates to what Rich just brought up, in smaller counties and jurisdictions, you often have a very close, almost in terms of you're the same entity, working relationship between the police and the prosecutors.
Close, that's a nice, kind word.
I use that term intentionally, close. Whereas when you get into the larger jurisdictions, where while there is a working relationship, most of those prosecutors are in a situation where they oftentimes will have to investigate and question the behavior and activities of the police.
Because their actions can't be insular. I mean, the reason why you can't do that in large cities is because there's too many eyes that are watching what's happening. And so, but for Facebook, but for social media, but for the media actually grabbing a hold of this story, the Trayvon Martin case would have been one of the other 70 cases that we're talking about we wouldn't even known about.
So the Florida statute, since we've been talking about it, has been under a considerable amount of scrutiny, and statutes like it. Apparently Zimmerman's attorney has come out and said that he's not relying on the quote-unquote quote, stand your ground provisions of the self-defense statute in order to make his case, that it's a straightforward case of self-defense. To what extent is the criticism of the stand your ground statute and similar statutes like it throughout the United States justifiable? Should it be essentially removed? Is it an appropriate extension of the basic self-defense defense?
Guns
Look-
make people, I'm sorry, Commissioner.
Looking at this particular no, I'm not the commissioner. But looking at this particular
Although you would love to
circumstance,
be.
no. Stand your ground does not apply in this situation whatsoever. This was not a situation where someone is attacked, that they're having to defend themselves without having caused the situation in the first place. So to attack the concept of the stand your ground law, I think is misplaced. I mean, that law is passed in Pennsylvania and numerous other states. It did not turn Philadelphia into the OK Corral with
Yes.
individuals outside. It's been in existence for almost a year. If it was going to happen, it would have already happened. The fact that it hasn't means that people understand that you can't go and start gunfights for no reason. The law is very specific in how it applies and how it is used. So it's not a situation where just because two idiots, for lack of a better way of putting it, decide to have a crossfire. One of my specialties when I was in the homicide unit was to do those types of cases and got convictions on situations where individuals didn't even shoot the person who ultimately died because juries found that the defense that they proffered, which was stand your ground, wasn't applicable because they created the circumstance which resulted in the gunfight.
Right. Ordinarily, as you know, and particularly the criminal procedure professor will certainly chime in, if you cannot avail yourself of self-defense if you're the initial aggressor. So part of what we're talking about is when Mr. Zimmerman, as the town watch person, and they're supposed to watch. They're supposed to watch and then notify law enforcement.
Watch and
right?
tell.
If you see something, say something. That's what they're supposed to do. In this case, he actually pursued and confronted. That certainly, it seems to me, caused him to question as to whether or not he could avail himself of this defense in the first place. Particularly now he's saying that it's just a traditional run-of-the-mill self-defense claim as opposed to the stand your ground claim.
It sounds like the person who has a right to stand their ground in self-defense was Trayvon Martin. Separate point as it relates to stand your ground in this legislation. It's wonderful. The NRA has made a conscious decision to push legislation, and whether we have it in Pennsylvania, whether it's turned it into the OK Corral, Leon and I will disagree. 300 people dead on the streets of Philadelphia is not all okie dokie for me.
But it's not based on stand your ground. It's
Well,
based
not
on, it's
all
based
based
on,
on- but you know
there are a
what?
lot of
I
issues
think
that come
there
into play
are
here.
people who decide to pull out guns for whatever reason, and just because if we use the same application they're using in Florida, if I hate to use his name, if Michael decides to pull his gun out and he thinks he's scared that this person is going to do something and he shoots him and he runs away, he will say it could be an argument that he was standing his ground and ran away. But that's not the point. The point here remains that this stand your ground law, this gun, you can have this gun, this made this guy Rambo. Philadelphia police officers all around the country carry guns. When they see a suspicious person, by and large they call for backup. If Zimmerman didn't have a gun, does he get out that car? I think the answer to that question is no. Did this law, the stand your ground law, give him this inflated sense of protection and immunity?
I can't say that would have made any difference in this circumstance. What I would suggest is that an individual like Mr. Zimmerman was certainly going to do whatever he could under the law. The question is, what was law enforcement or an objective body going to do in evaluating his actions? That's what the issue is. It's not really a question of whether or not Mr. Zimmerman would have done something different. I would doubt very seriously he knew anything about your stand your ground law. I doubt that very seriously. But what I do know is he thought that it was important for him to confront someone on the street, and he thought that it was something that he could do, and certainly when he availed himself and used his firearm to protect himself, that he certainly found the protection, and that's why they called his father at some point within the first hour and a half, who happens to be a district magistrate or something like that. And
You have to ask yourself what
So-
effect that
The
had.
discussion to you, one of the criticisms that people sometimes have of law school is that you go in thinking one way and come out thinking another way, and somehow twist our ability to understand things from a common sense perspective. So, from your perspective, what are your thoughts with respect to the relevance of this statute and the way it impacted this case?
Well, it's the same with the seminary. You go to the seminary, they usually call it a cemetery, so it's ironic. So you'd have to just be grounded. But for me and where I sit with this, I do believe that there's a point in here because Trayvon is an African American, could he have been profiled? That's one of my questions for the attorneys here. But also, at what point does the United States Justice Department take over a situation like this? At what point, since there are so many inconsistencies, do they have a right to do that at this point?
They do if you have a situation where someone is alleging that his civil rights were violated. At that point, that moves it into their jurisdiction, and they can then examine both the actions of the individual who allegedly violated his civil rights, as well as the local authorities who didn't do what they were supposed to protect his civil rights.
And so in this case, they'd be evaluating the state actor, and who would be the state actor for the law students?
The state actor in this particular circumstance would probably be that prosecutor, because he was the one that made the decision not to charge.
I think
Well,
they could also get
prosecutors are
jurisdiction.
immune, correct?
In terms of certain things, I'm not saying the state prosecutor is going to be charged. However, his actions can be reviewed by the Justice Department.
And I think the other question is whether or not this is a hate crime. There has been some discussion on whether or not some type of racial derogatory term was used. And does that elevate this to a hate crime?
That would also put it into federal jurisdiction if
I
they
don't
made
know.
a determination.
I had a conversation with Senator Specter the other day, and he was one of the co-authors of this hate crime bill. He said one of the reasons he did it was because after Robert Byrd was dragged to his death in Texas, the local prosecutor declined to prosecute initially. So it gave the federal government a hook to say, if the local prosecutor is not doing something right, and we believe this is based on race, we can have jurisdiction. And you don't have to prove beyond a reasonable doubt that it was based upon race, just a preponderance of the evidence. So if the word, for example,
If there was an animus, if you can demonstrate some sort of racial animus.
Unless it increases the penalty.
Let me jump in here for just a second. We've got about 10 or 15 minutes left and sort of open it up to our audience members, questions you might have for our panelists. And I'll ask you just to direct your question, if you can, to a particular panelist. Wait for the microphone to come to you, and try to keep your question relatively short, if you can, and not multi-part. So that we're not having to write down the various subcomponents of your question. Yes, sir.
Well, I have a question for the entire panel. I just want to know what is the exact difference between an ordinary self-defense law and this stand your ground doctrine, because I'm under the impression that with the ordinary self-defense law, the person bringing the defense can't provoke the attack.
SPA.
And with this stand your doctrine law, it doesn't say it at all in the whole paragraph. So, if he were convicted, if Zimmerman were convicted, and his lawyer went under this defense, wouldn't it be harder for him to be found guilty under this defense? Because with ordinary self-defense laws, you can't provoke it, but this doesn't say it at all. I was just curious. I don't know the difference between an ordinary one and this one. So
how does it, let me just try to rephrase and point the question. How does it differ from typical self-defense? And perhaps you can just touch on the difference with respect to duty to retreat.
In Pennsylvania, before you are legally allowed to employ deadly force, before the law changed, you had to make a reasonable effort to retreat or to comply with whatever the demand was. So if you're in a situation where someone is robbing you, you got to give up your wallet. Once you've given up your wallet, if at that point they then continue, okay, you're in a position at that point that if you can articulate some reasonable basis that a reasonable person would think that I was in danger of death or serious bodily injury after I've complied, then you would be allowed to defend yourself. With the change in Pennsylvania law, that element of retreating and complying has been stripped away.
It's the same thing under the Florida statute.
Exactly.
As well.
So
The general rule is you have to retreat, but under the stand your ground statute, you do not have to retreat.
right.
Right, so if you can verbalize the fear that you're in, and the person, i.e., if someone walks up to you and says, give me your money, that's probably not a situation where you're going to be justified pulling your weapon. But if they have a gun pointed at you and they say, give me your money, now under Pennsylvania law, and Florida appears to be the exact same, they appear to mirror each other, you don't have to give your money. You can stand your ground and draw your weapon and defend yourself.
Okay, because just real quick, because from the facts from what I gathered from the news, Zimmerman went up to the kid, and from a reasonable understanding, I think that the kid Trayvon probably did hit him first because he was scared. With that being said, Zimmerman provoked that
Let's assume
attack.
that he hit him over the head with his bottle of iced tea. So if he hit him over the head with his iced tea, I think it was a can. Let's say he hit him with the can.
Right.
He punched him 10 times in his nose. Do you think that that was reasonable for him to receive deadly force as a response to that, him getting beat up?
No, I don't, but the law right here says reasonably believes it's necessary to prevent death, but it doesn't say that he doesn't have to provoke it. So if Trayvon was beating him over the head and he reasonably believed that he was trying to prevent bodily harm to him, I think that, sadly, that he could defend himself under this law.
I would give you this.
Well, he did, and that's why he hasn't been prosecuted thus far.
For example, if he was stalking or harassing, the statute begins off a person who is not engaged in an unlawful activity.
Exactly.
There is a reasonable basis to say he was harassing him, he was stalking him, he was doing some type of unlawful activity. It doesn't give them protection on that statute. This statute gives you the criminal defense attorney. He's my mentor. He always says no to everything I say, but just ignore his head shaking. The point, that statute doesn't necessarily give him this great power to walk away from this. I think that your question was, what is the difference between this and self-defense, right? Professor Malone?
It's the retreat.
It's the retreat. It's the retreat.
It's the retreat element.
The retreat element has been stripped.
Let me move forward, yes, ma'am. We're taking a microphone right here to speak up very loud.
If you look at the statute, it says that it has to be you have to be justified in using such force. And you were talking earlier about how it really should be this objective standard, but in this case, it seems like it was more subjective. Ordinarily, it should go to the finder of fact, a jury, but in this case, they didn't. Do you see this as being a slippery slope, as somebody being able to shoot somebody and saying, "Oh, I thought they were going to hurt me. I feared for my life. There was deadly force necessary." Do you think that this could continue and get worse?
Well, apparently, prior to this case, there were over 100 and something cases that fell in line under the stand your ground statute. So apparently, they had made the determination. Local prosecutors in Florida have made determinations that if people availed themselves of this defense, that in fact they were not going to charge them with an offense. So apparently it is working, and under these circumstances, the number of fatalities have increased where people have actually claimed this defense. So apparently that it is. It's becoming more difficult in terms of the number of instances that are occurring where people are saying are getting shot and killed, in fact, where individuals are not being charged, based on the statistics since the statute has been enacted.
Very rarely do you see a statute give someone immunity from criminal prosecution for use, even if they use some type of deadly force.
Well, I don't think the statute does that.
It does.
No.
Do you feel like that's too over the top?
I don't think it does. I don't think it's,
It
the
says the
application, I don't
person
think
who
it does.
uses force is justified in using such force and is immune from criminal prosecution.
I understand.
If it's found, the prosecutor makes
If it's found,
If it's found, that's the clause.
right.
It doesn't say that.
And
Criminal prosecution also includes arrest. So it even gets
Yes.
before it gets to the prosecution.
Absolutely.
I think, and that's a
If
higher
it's found.
standard, and that's a slippery slope of questions that I
It
have.
does say that.
I spent 2 years in law school
That's the
trying to figure
statute.
out
That's a
reasonable
scribble.
person.
Some scribble. This is-
I pulled this stuff.
As Charles said, my tour professor is in the audience, so she can testify to that. But now you're putting in the hands of someone who hasn't been trained in law school, although in criminal investigation, a police officer, to determine reasonable person standards, even as this statute reads, before even arresting.
Let me
Arrest if the police officer.
That's incorrect. Well, no disrespect intended, but that determination of whether or not it applies, the prosecutor makes that determination. The Supreme Court has already made determination that a police officer doesn't have that authority to make that type of decision. Ultimately, it's the charging prosecutor, whether it's a state's attorney, DA, whatever. It's the same as if you have the circumstance where you have an officer involved in an interrogation. He promises an individual, if you give me certain things, you won't be charged. He doesn't have that authority.
So in jurisdictions where I guess affidavits of probable cause or arrests are made by police officers, this isn't a hurdle, a statute like this.
It's ultimately the prosecutor that still has to make that decision, even in that type of
What the police
jurisdiction.
department basically does is gather the facts and give it to the prosecutor. I said either he agree with it or disagree with it. But a lot of times what I found is that if they didn't agree with it that particular day, they would give you more direction to go to. We want you to do this, we want you to do that. They wouldn't just stop at that particular night. If the homicide detectives feel as though this is important and he presents all these facts, and, you know, the prosecutor says, no, I'm not going to do it. I mean, there's nothing the police department can do at that point because he's the one that's going to have to take it to court.
And let me just jump in at that point. Both Commissioner Johnson and Reverend Newberry referred to that idea that the police had initially sought some sort of arrest warrant, and that's the case here. Detective Chris Perino had actually filed an affidavit with the prosecutor's office requesting permission to arrest, and it was the initial prosecutor who denied that request. Okay, so another question.
I think this is more in the way of a comment. I was teaching about the topic of malicious abuse of the criminal procedure, which is a civil remedy, a tort action. And one of the things we were talking about is that the person who brings that cause of action would have to show that there was that the defendants instigated, overcame, if you will, the prosecutor's determination whether or not to prosecute. That, in other words, we had an awful lot of pressure brought to bear on the prosecutor so that ultimately it's almost like his or her discretion whether or not to prosecute was overrun. And I was interested in this panel because these cases are far and few between in tort law, but I was wondering if any of you could comment, or if you cared to comment, on the fact that perhaps Mr. Martin's parents could ultimately be faced with a civil suit, just looking at this one particular element in the sense that, look, you know, there was a determination not to prosecute, and you put all kinds of pressure on the prosecutor to bring this cause of action. And that can result in substantial civil damages if the other elements are met also.
Sure.
No. I didn't have that class with her. You didn't teach that in my torts class, right?
Interesting.
I think we agree with you, Professor Turlston. Next question, please.
Okay, I have a question. Whether it's self-defense or they use to stand their ground, it seems that the fact that he used deadly force, he kind of has no defense. So I can't understand why he wouldn't allow him to be arrested. So I guess my question is let's say he hit him in the head with his can and punched him 15 times. Is that force against his deadly force meets that deadly force? I don't know.
That's something that I would say no. I mean, one of the cases that I handled, which involved...
I'm not familiar with any cases under the sun where Mr. Goodman elected not to prosecute.
But I did, after I convicted one of your clients, not put him in state prison as long as I possibly could.
That's true.
Because he approached me appropriately.
That's true.
So don't make it out like I have no heart. But
one time he pleads out.
one case that I recall that I dealt with where you had a situation just like that. You had a fist fight that escalated into people shooting at each other. And the defense that was presented in this particular circumstance by the guy that I was trying at that point was, A, I didn't shoot anybody, which he hadn't, and B, if I did shoot someone, it was because I was defending myself. And in that particular circumstance, the jury didn't accept that defense because he created.
Did you say jury?
Did not accept that defense. That is correct.
So they had 12 people in the box who made that dedetermination.
But we charged the individual.
Right.
And it wasn't because of the fact that he was related to Joe Frazier or anything of that sort. It was because under these particular circumstances, the individual that caused the shooting, which resulted in Joe Frazier's relative being killed, started the chain of events that resulted in the death. And even though he claimed I was defending myself, we as the prosecutors determined that we would not accept that. And because our determination that there was probable cause on murder generally, we charged him and took it to the jury. So the prosecutor, again, ultimately has to make that determination. Why that happened in this particular circumstance, I obviously cannot explain because I'm not in the mind of that prosecutor. But if I was in Florida, I'd have charged.
Yeah, but I think the problem is that there's not enough factual evidence that we know. He may have said that night, we're not going to prosecute that night. I want more done. It might have been somebody higher than him later on that says also is that, look into it more or end it. in his mind, that particular night, he may have just says, look, there's not enough, I want more done. I mean, we're putting a lot of things on this prosecutor, but we don't know for a fact that that ended the entire investigation. And I'm sure somebody higher than him made the decision that night other than him.
Other questions?
Yeah.
Up in the top row, yes, sir. Raise your hand right back there. Yes, sir. And Jennifer. Oh, no, back there. Okay, Jennifer. Oh, sorry. Go ahead, Caleb.
Thank you. I know we've mentioned that there's sort of, this issue of maybe there were racial overtones in the fact that the police or the prosecutor or whoever decided not to charge Mr. Zimmerman at the time. But even if we were able to, if there were better safeguards in place to prevent that kind of problem, isn't the larger issue the fact that, Mr. Zimmerman, it seems, may have been motivated by some sort of, profiling or something like that when he approached Trayvon, and you're really not going to be able, there's really no sort of legal recourse that would be able to prevent that kind of thing from happening in the first place. Isn't that sort of the most difficult issue with all this?
Let me ask Reverend Newberry to jump in on that.
Let me answer it a little bit unorthodox, but what you don't see in here, I worked for the gang control unit for 7 years and was a federal probation and parole agent here in the Eastern District of Pennsylvania. Unfortunately, the one who could really bring all of this to light is dead. So then you have the community doing what they're doing now in terms of our reaction to all of this. But can you imagine 17 years old, and in particular, I'm just going to say African American. I don't know of too many young 17-year-old males in our community that would not respond to Mr. Zimmerman without force. If he came upon them, as we all could sit here tonight and assume, and we see it every day, it's going on, but at the end of the day, there is some form, we could say, of profiling, and of course, we could all sit on this panel and, we respect each other's position, but at the end of the day, this young man is dead. He's dead, his parents are without a son, and we have a responsibility in our community to respond to this, but also on the other side of this is educating our young men and women on certain types of behaviors, and we recognize that even when we educate them the same way, something could possibly happen. Unfortunately, a couple of weeks ago, it was interesting. My pastor was in the elevator, we're out of town. He's on the elevator by himself, and a woman gets on the elevator, and it's real. And he had on his athletic gear. We're working out, and we do a lot of martial arts at our church. But he's on the elevator, just so happens he has his hat on backwards. The woman clutches her pocketbook, goes to the back of the elevator. And that could happen to any one of us on this panel. It doesn't matter what our age or whatever. Later on that night, we were going to a convention. The same woman said from her own mouth, "Aren't you a celebrity? Aren't you a sports figure?" But you see, 9 hours later, her whole attitude had changed because he had on a suit. 9 hours prior, because he had on athletic gear and his hat on backwards, her position was one of defense and afraid. And I think part of that is what we see going on, not only in this case, but in many cases across America.
And last question, and then we'll look at this last question.
I think
there was a question about legal remedies.
As it relates to the legal remedy, Leon, you want to go? I think that, in my opinion, the hate crimes legislation would be the thing that governs this. If that's the legal remedy here for a prosecution. If race was a factor, that is the hook for the federal government to make it to at least make a arrest or an indictment or investigate.
That can also amplify the charges in question, in particular on the state level. if the local prosecutor, the special prosecutor determines that race was a factor in Zimmerman's actions, in that particular circumstance, he can be charged statewide with the ethnic intimidation on top of any type of homicide charges. And I presume Florida is similar to Pennsylvania, which would amplify or make the ultimate sentence higher as a result of that amplification for the hate crime. You also would have a civil remedy, which is something that Mr. Harris would probably have a lot
Then you could also
more.
file civil actions against either the state for a civil rights violation, or you could actually file a civil suit, a normal tort. In this case, it would be a batter in civil court against the Zimmerman or Zimmerman family.
And also, the homeowners association may have a reason to have a cause of action.
It's a condo association.
The condo association.
Right, if they had Zimmerman
They had
as
Zimmerman out there
the town
as
watch,
their town watch person,
that
say,
could
call
open them
George
up.
if something's wrong.
The civil guys like that, so we would be suing everybody.
Okay, Jen first, and then James, and then I'll finish this up.
Okay, unfortunately, Professor Holbrook gets a two-part question. I apologize. I'm by no means defense-minded at all, but to play devil's advocate at all. I know.
I know her.
But we know there's been a great public outcry, and we've spoken that Mr. Zimmerman's belief is based on an objective standard. So let's say that he does hopefully get to trial. How does George Zimmerman get a fair trial? Because everybody knows about this case. People are up in arms about it. So how does that happen to my former prosecutor and former defense?
The only question that I would have is whether or not they can put aside what they've heard in the media. If they can put that aside and under oath promise to give both sides a fair trial, I wouldn't have an issue with that particular person as juror.
I would, obviously, the first issue is whether or not you could find a jury in that particular jurisdiction. It's more than likely, if I were representing the defense, I would try to move the case. I'd probably move it to another jurisdiction, change of venue.
I would object, of course, but.
I can assure you he would object to that. But you certainly want to have an opportunity where the media attention isn't as severe, where the members of the community don't have to worry about what decision that they make, they have to return back to that same community. So obviously we'd want to separate the jurors or the prospective jurors in a location where they can actually feel comfortable and they can evaluate the evidence fairly and objectively.
The second part to my question for the Reverend and Mr. Johnson as well. If, God forbid, he does go to trial and is found not guilty for whatever the reason may be, whether it be defense or something else, how do community activists respond to that? How do you, speak to the public and give them some sense of solace in what might have happened?
That's a wonderful question.
I think that's going to be hard to do. I think there's so much emotion going on right now. Even if it's at this point that the prosecutor decides, I'm not going to arrest him, I think you're going to have outcry from the public. There's going to be, from different parts of the cities and the different cities, there's going to be some sort of outcry. I don't know how the Reverend's going to do it, but I don't think the community is just going to accept that. Reverend Sharpton's been saying on the news, he just wants him to go to trial and get a fair trial, but he should be arrested to get that trial. All the evidence is brought out. And at this point, all the evidence has not been brought out. We don't really know what the evidence is at this point. But, as far as the police department is concerned, and I've been out of policing now for the last 4 years, I think they're going to have a problem. They're going to have to put themselves on alert. If that comes out, that she's found not guilty, just like with this Anthony case, people, there was outcry when that happened, when she was found not guilty. And I think in our community right now, no,
Rodney King.
right.
Rodney King. And I think it's closer to this, where you have a white-black issue. There, black people are upset. There are some conservatives who are saying this was justified. Race is involved. I think the closest thing to this may be Rodney King. This is not Casey Anthony.
Right.
This is closer to Rodney King.
But I'm saying you have people that had that outcry there, and I think you're going to have an outcry if he's found not guilty, or if he's not, or even if he's not arrested, we're going to have problems.
And it's more so, understand he was 17. 17-year-olds across America aren't afraid of anything or anybody. So I agree with the commissioner. That's where our outreach should be toward those teenagers?
Well, I'm more concerned. I mean, quite frankly, people have, when I say people, I mean the community typically, we are vested in having a process that works.
Right.
So if we have a process that works and people feel that they have some sense of integrity in the process, as long as there's someone that gets arrested appropriately, we think that that would happen, that the person has a fair and safe and impartial trial, then I think I would be surprised if there was a huge outcry just based on the virtue of someone finding them not guilty. Now, if there is a jury pool where that pool is not representative of the community, then that would be a factor. But if you're talking about individuals that are people of color that are actually in the jury, that are selected as part of the jury, and they decide not guilty, I don't think there will be a huge outcry.
Okay, last question.
When it all boils down, do you believe, or any of y'all on the panel believe, that the special prosecutor will actually charge Zimmerman?
Absolutely.
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 I think he will. I think she will charge.
And why?
Because I live in these United States. So I can assure you, if she were going to let me say this, I won't say that. I'll start off. There's the possibility that, yes, charges will be lodged. I doubt it very seriously. Because if she were going to do that, I would suspect it would have happened by now. How long has she had the case? She's had it more than 2 weeks, right? It doesn't take that long to prosecute someone, to charge someone with homicide. It doesn't take that long. To manslaughter, even manslaughter. It doesn't take that long to charge someone with manslaughter. Ordinarily, Commissioner, you can chime in if I'm wrong, but let's take the classic case of these young men and women learn in law school. The classic manslaughter case is a crime of passion. You come in, someone comes into you come home from work, you find that your wife is sleeping with another man, you shoot him. How long does it take you to prosecute that person?
Well,
That's a classic. Isn't that the classic manslaughter case, right? It's a crime of passion.
It is, and it wouldn't take that long. But I think in this particular case, because of the public outcry, they cannot make any mistakes at all. Exactly. And they're going to have to go step by step by step. And
For charging?
Yeah, even for charging, they're going to have to make sure that everything is done 100% correct.
I agree with the commissioner.
There's no mistakes.
And I think she's going to charge.
I think
that's the reason
I
why
think
she eliminated the grand jury, because she looked at the evidence, determined that there was enough, and decided to make the call, which is her job to do.
I hope you're right.
And also, the other thing you have to look at, what is her name? Do anyone know her name?
Conrad.
Stacy what?
Conrad.
She will be running for public office soon enough. There's a reason that she punted, did not punt to a grand jury. She's going to prosecute. She's going to...
Angela Corey.
Whomever she is, whatever her name is, she will be running for public office soon enough. And I think that may be the primary motivating factor behind why she said, you know what, I'm going to do this myself. There's such a public outcry in Florida, white, black, everyone. People are fired up.
I hope you're right.
I'll write her a check. If she gets a conviction.
So we're past the 7 o'clock hour now, so let me go ahead and ask for an end to our questions. If you have questions to our panelists during our mix and mingle afterwards, if you would like to chat with our students, I'm sure many of them would love to chat with you. We sort of invite you to that, and hopefully you'll stick around for just a few minutes longer. But on behalf of all of us, thank you very much for attending
Got one of my big brothers up there.